Okay, I hope you are all back for this last session in our pro-life conference. Thank you so much, all of you who have participated in this. Thank you for your questions. We're just excited to be able to offer this on an online format. I know that it is really sad that we can't meet in person for all of the things that we want to meet in person for, but we still wanted to be able to give you some of the things that you learned during our annual pro-life conference. At the same time, I know some of you who aren't usually able to travel to Lincoln are able to tune into this. So we are happy that we give you a new opportunity to do that. And hopefully that means in the future, when we do meet in person, we're able to offer an online stream for those of you who want to hear all of the good things like the things you've heard today. If you have any follow-up questions about the people that you heard from today, or their organizations, or the books that were plugged, you can always email us at nebrcc@anycatholic.org. You can go to our website and fill out a contact form. And of course, you can always call our office at 402-477-7517 or visit our website at anycatholic.org. For those of you who are not familiar, the Nebraska Catholic Conference is the public policy arm of the bishops here in the state of Nebraska. We work in the legislature, lobbying for bills. We support and oppose bills. We go in front of hearing rooms and talk about the church's position on certain issues. And also we do a lot of education, so letting Catholics know what's going on in the legislature, in statewide public policy realm. As you know, there's an election going on. Maybe if you've turned on your TV or done anything ever, there's an election going on. So if you still haven't filled out your ballot, if you are going to vote in person, and you haven't already checked out our voter guide online, it's nebraskacatholicvoter.com. You can see how candidates answered our survey. And also we've taken positions on a couple of the ballot initiatives that are on your ballot. You can find more information about that at our website, anycatholic.com. But just a reminder that we are supporting the payday lending ballot initiative number 428, and we are voting against the expanded gambling initiatives for 29, 430, and 431. And again, you can find more information about that at anycatholic.org. Don't want to get too much into it. Obviously, we're just in a pro-life conference, but those issues do have a big impact on the lives, especially of the poor and vulnerable here in Nebraska. So please keep those in mind as you go to the ballot box or as you drop in your ballot into the mailbox. Very important things on the ballot today, or this month, not just the presidential or other elections. But all right, so speaking of public policy and the law, we of course want to give you some perspectives on that, as we are the Nebraska Catholic Conference after all. Hang on a second. So we are happy to give you this talk, Roe v. Wade and Redeeming the Law. So we've heard a lot today about how we can redeem our culture, how we can, work to change our political culture, just how we can reach out and love the people right next to us. And that is going to be the most important thing and the thing that we can do immediately. But, it is also really important that we work to defend laws, to make laws, pass laws that honor the dignity and worth of the human person, and especially the most vulnerable among us, the unborn. So Marion Miner, our Associate Director for Pro-Life and Family, is going to talk a little bit about that. And we are going to get started right now. Marion, take it away.
All right. Thanks a lot, Lauren. Thanks to everyone who has stuck around after that talk by George Weigel, which was wonderful. I want to thank George, too, for your reflections and for taking the time to be with us this morning. I really, really enjoyed getting more deeply into some of the things that I learned from you last summer at the Tercio program. in Krakow, which I was privileged to attend last July. Anyway, always good to listen to George Weigel. George, if you happen to still be with us, very, very grateful for your time here. So as Lauren mentioned, and I think as most of you probably know, I work as the Associate Director for Pro-Life and Family at the Catholic Conference. And as such, it's my primary responsibility to represent the Catholic bishops on on issues relating to life, human dignity, and the family as it relates to state policy and the type of legislation that is proposed in our state legislature. So what I'm going to try and do this morning in as brief a time as I can, really, because I don't want to belabor you too much. I want to reward you for sticking with us this far. Is attempt to build a little bit about what the panel talked about this morning, and especially what George, our keynote this morning, have presented in the last couple of hours. And specifically what I want to build on and touch on particularly is what does our understanding of the times that we live in and who the human person is and what the human person is for tell us about the law and what the law should be and do. And we know that our law has been distorted and compromised by many injustices, including Roe v. Wade and the wanton destruction of the unborn. So in our mission then to redeem the time, what does it look like to redeem the law and how do we go about it? So that's kind of the mission here in the last 20, 30 minutes or so. And then at the end, I'm happy to take questions either related to that subject or about the work that we do here at the Catholic Conference, or about anything that we've been up to in the last few years and will be up to in the future. So I want to start with then just talking a little bit about what the law is and what its purpose is. As George mentioned, the law is more than a protector of rights. It exists for more than to provide an arena for the willfulness of individual actors. It's more than just the bumpers around the arena through which we get to live out what we want our lives to look like, to live out our desires and dreams. The law is an ordinance of reason, so it's a command made by the person or body that is in charge of taking care of the community for the common good of that community. And when we talk about the common good, we're talking about this sort of organic unity of individual parts working together for its proper end. Now, classically, something that we have inherited from the Greek and the Roman traditions of law, this common end that we're all ordered toward is the flourishing of the city, the flourishing of the community. And that is a legitimate end, and it's something that a Christian community is ordered toward as well. But we have in the Christian tradition, of course, that we've inherited from Jerusalem, the additional end and the higher end of unity with God. So in our communities, then, all parts, human beings and institutions, play their own part in bringing about this unity and working toward this end. And law should make that easier for us to do rather than more difficult. So this notion of the common good then is everywhere in the classical tradition, and it's inherited especially from the Greeks and the Romans. With the Greeks, you find it in Plato, in his Republic, and in other works, in Aristotle in his Politics, and especially in Cicero as a Roman source. And in addition to this notion of the common good, which is always in the background and is an important part of Catholic social teaching, we have the notion of the dignified human person with rights that can't be violated by the state. And this is only possible in a culture that's leavened by Christianity. Because the idea that the human person, and every human person, regardless of his status, regardless of his usefulness, regardless of his gestation or location, every person is created in the image and likeness of God, is something that we have inherited specifically through the biblical tradition. And when this is then sort of baked into, when it's when this additional notion works its way and permeates our idea of what the law should be, along with the common good, what we end up with then is a specifically Christian culture of the law. And this idea then of the dignity of the human person leads very early in the 1st century AD to Christian condemnations of abortion in the earliest writings of the church. Many of you may have heard of the Didache, also known as the teaching of the 12 apostles, which is considered by many of the church fathers to be next in authority for Christians to sacred scripture. And specifically in that text, the Didache forbids killing the child through abortion or destroying an infant already born, which in the classical world was all too common because of the danger of abortion. So in the Christian legal tradition, which is our heritage too, in America, we have the blending of the best of Athens, of Rome, and of Jerusalem. And that is the foundation of our Christian culture and our Christian law. We have the revelation that was carried on by the Jewish people, which is then married to the Roman ideas of law and the great philosophical tradition of the Greeks. Now, we see then this marriage, which leads to an emphasis on the dignity of the human person, lead to changes in law, and we see legal prohibitions of abortion even in medieval Europe, going back at least to the 1200s, if not earlier. And the English common law, which was judge-made over centuries, rather than statutory law passed by Parliament or Congress, for example. Judge-made common law, which is the foundation of American law in the early colonies, made abortion a crime. And the American colonies adopted this and made abortion a crime itself in our own colonies and in the young United States. And so this is our tradition. This is our legal and cultural historical inheritance. And this leads to something very interesting, I think, in the history of law in the American context, which is then its translation to this new country, the United States. And this notion then that is sort of memorialized in the Declaration of Independence, holding as a self-evident truth that all men are created equal and that they have an inalienable right to life, is something, again, that's only made possible in a culture that is heavily leavened with Christianity. Because these ideas of inalienable rights that are given by God and cannot be taken away by the state, and this notion of specifically a right to life, and the fact that all men are equal in dignity, this is something that is not possible outside of a Christian legal culture. And so even then, today, of course, in many ways, we've departed so much from this tradition, from this beautiful understanding of the worth and dignity of the human person. But yet, the residual effects are still so apparent in so many ways. These notions of rights, the notions of treating others as equal under the law, these are a part of our inheritance, our legal, cultural, historical inheritance. So what I want to touch on real quickly here is, so we have this development in early American law in continuity with our classical and Christian legal tradition. But it takes on sort of a new meaning in an aspirational way with the Declaration of Independence. And St. Augustine has a really beautiful reflection about legal customs and traditions and how those arise as certain aspects of a people's understanding of justice and natural law, and how these customs and traditions are, these certain aspects of justice and natural law are emphasized that are for reasons that are particular to a place and time. So this tells us something really interesting and really kind of beautiful about America and its founding. which recognized and emphasized the dignity of the human person and the need for the inalienable right to life. So one thing that that George made mention of too earlier is the institution of slavery and racism as sort of one of the original evils and failures of our nation to live up to those high ideals, which are expounded in the Declaration and in our Constitution. And I want to touch briefly on that legacy, slavery, as a failure, because it does have some things to teach us about the right to life and our failure to live up to our ideals with regard to the unborn. So slavery, of course, violated both the norms of the common good and the dignity of the human person. And I think we can learn a few things from that historical example. The first thing is that the baking of that kind of evil into our law not only violates the dignity of the human person, also poisons the national well, so to speak, by making unity around the common good impossible, because it excludes some persons from that communion. So also, of course, with abortion, and why it must be totally eradicated. But there's a cautionary tale that's built into there too. And there's a quote by Abraham Lincoln that I think is very instructive here. And he says that without public sentiment, nothing can fail. Against it, nothing can succeed. And of course, he's talking about in the political and legal realm. Whoever molds public sentiment goes deeper than he who enacts statutes or pronounces judicial decisions. Slavery had ultimately poisoned our national unity so thoroughly that many states tried to leave the Union, and we had to go to war in order to preserve it. It took a war to preserve the unity of the nation. And the wounds that that sort of national sin left in its wake to this day are still painful. But public sentiment, which brings about sort of this cultural consensus, which the law needs in order to hold together and be settled on a firm foundation, is ultimately won by appealing to unifying principles. And that's something to which George was appealing earlier as well. You have men like Frederick Douglass and W.E.B. Du Bois and others, African Americans, appealed to what was true and good and unifying in our culture, in our legal and cultural inheritance. And they recognized it as good, but they recognized our inability to live up to those aspirations as well, and to really worthily live out this heritage, this inheritance that we've been given. And instead of condemning this inheritance as irredeemably bad, what they did was appeal to what was good in it and work to remedy the flaw. And Martin Luther King Jr. did this as well, citing not only American sources for this, but also St. Augustine and St. Thomas Aquinas. And something to mention here too is Pope St. John Paul II has this wonderful and pretty short book called Memory and Identity. And one of the points that he makes in this book, and this is really about about nationhood and patriotism and identity. And one of the points that he makes is that it's a mistake to think that if the common cultural bonds that define a nation disappear, that the nation can still be held together by virtue of government policy, either imposed from above or arrived at by majority vote. Because the people have to be united by common bonds of culture before they can see either government policy or the will of the majority as legitimate. So that's ultimately what we have to. George alluded to, again, a question was asked about whether culture, which is downstream of which, right? Culture or the law. And the culture really does, the state of the culture and the state of whether we have national consensus over things, over first principles, really dictates in many ways how firm a foundation the good laws that we have rest upon. And so the law is a teacher. The law can help to redeem the culture and to move the culture in a good way and to strengthen those good foundations. But without this, as Abraham Lincoln says, public sentiment, and more deeply without national consensus over first principles, that foundation is much weakened, even if it's enshrined into the law. Okay. So with Roe v. Wade in 1973, we have what Justice Byron White, who was one of the dissenting Supreme Court justices in that case, along with William Rehnquist, called a raw act of judicial power. And that broke with our historical and legal tradition and built upon then a foundation of lies. And again, to quote Pope St. John Paul II from Memory and Identity, what we had building here leading up to Roe v. Wade in 1973 was what he called a new ideology of evil, which is more subtle than the ideologies of Nazism and Marxism that caused so much death and suffering in the 20th century. But he reminds us to take courage. God imposes limits on evil, and he permits it to reign only for a time. And how long that time is up to him, and we have to trust in him and make ourselves willing instruments of his divine providence. So with regard to Roe v. Wade, this is historically preceded by court cases that began to break down our understanding and our cultural consensus around marriage and the family and human sexuality. And those are memorialized especially in two Supreme Court cases in 1965 and 1972, with Griswold versus Connecticut and the Eisenstadt case, both of which related to contraception, first for married couples and then for non-married couples as well, striking down laws that restricted the sale of contraception. So, and I mentioned too that so we have this foundation of Roe then built on legal precedent that's built upon misunderstandings of marriage and the family and human sexuality. And Roe v. Wade, when it arrives in 1973, builds on these misunderstandings and adds on top of them legal and historical, as well as medical and scientific and anthropological misunderstandings, misunderstandings about who we are as a human person. So one of the lies, the legal and historical lies that Roe v. Wade was built upon, is that abortion was the norm in world history and only made illegal later on in American history, say in the mid to late 1800s. But as we spoke about earlier, the truth of the matter is that the common law, the judge-made law, which is not written down in statute books, but it's memorialized in court precedents, this is what we inherited from England, and this did prohibit abortion. And when it became more of the legal norm for our laws to be set down in statutes and not simply memorialized in court cases, at that time in the 1800s, the state government started to pass laws forbidding abortions. And by the time we got to 1970, 1971, and further, we had over 30 states that very expressly forbade abortion, except in some cases to save the life of the mother, and some other cases. And actually, we had some pretty serious legal momentum, legislative momentum, in the few years leading up to Roe v. Wade. 1967 was kind of the first year where you started to see laws passed in some states that started to push back and legalize abortion for broader purposes. And they had some momentum for a few years, but by 1970 and 71, actually, many of those laws, all of that pro-abortion momentum in state legislatures had been stopped. And actually, new laws restricting abortions were coming into play. What Roe v. Wade did was stop that legislative momentum and stop this process by which people in the many states of the United States were coming to an understanding, a common consensus about who the human person is and why it deserves protection, right? Which was in continuity with our classical and Christian and American tradition about protecting the individual human life and recognizing his worth from the moment of conception. And in fact, even as early as the late 1800s, there were judges in their decisions upholding statutes that restricted abortion, stating explicitly that by that time, the late 1800s, new science and medical discovery had cemented without a doubt that human life begins at conception. And one of the things that Roe v. Wade did was actually ignore this entire history, not only our legal history of protecting unborn life, but also the medical and scientific consensus that had been arrived at many, many, many decades before 1973. And Roe v. Wade, for some technical reasons that would be pretty boring, didn't actually take into account, didn't actually receive into evidence any of this scientific literature or the history behind all that, which would have made ridiculous the claim that we simply cannot know when human life begins, which was the claim put forward by the Supreme Court in 1973. And to finish off sort of the lies that made up the foundation that Roe built upon, we have this anthropological lie, this lie about who the human person is. And this lie is that the value of human beings is determined by their wantedness or their utility. And the truth that we know, of course, is that every human being is created in the image and likeness of God. And that if we devalue one group or another, then the security and the recognition of value of human beings, of all human beings in our society, is endangered. And here we can think of not only abortion, but also euthanasia, the intolerance of disability, racism, and genocide, which are some of the things that we've seen play out in the real world in the not too distant past, when you have an abandonment of this principle of the dignity of all human life, which again is only possible in the particular context of a society that is leavened by the Christian faith. So Roe struck down abortion laws in all 50 states and imposed abortion on demand across the country. As we said, kind of stopped this national momentum that had been building. So the battle that we have fought since then has been lawful resistance, attempting to win public sentiment, and using the contradictions in Roe v. Wade against itself to undermine not only its sort of cultural implications, but also its legal foundations. So we've passed pro-life laws that show the public the humanity of the unborn child. For example, LB 814, which we just passed this year, I think really helped people to understand what happens in an abortion during those procedures, and how far advanced actually the development of the human child is at that time. It's really quite striking how the lack of understanding that much of the public has with what happens in an abortion, and how far developed the human being is. So many of these laws, besides actually limiting abortion, also teach the public about the nature of the unborn child, the humanity of the unborn child. The 20-week ban, and Nebraska was the very first state to pass that in 2010, I think did that as well. Another popular piece of legislation that has been introduced in many states are bans on abortion for reasons of the disability of the child, the diagnosis of a disability. This again recognizes the humanity of all persons, but that starts in the womb. We've passed pro-life laws in our nation that increase safety for women, like clinic regulations and informed consent. This again really strikes at one of the foundations of Roe, which is that abortion is women's health care. We've passed pro-life laws that attack the narrative of choice, right? Like abortion pill reversal was something that we passed in 2018, and informed consent laws that force abortionists to actually tell women what they are in for if they go through with this. George also mentioned the non-legal work of pregnancy resource centers and hospice, and we should add also the public witness that we provide at the Walk for Life, at the March for Life, and in front of Planned Parenthoods and other abortion facilities across the country. These things, as well as, to go back to legal progress, laws across the spectrum in our statutes that protect unborn life that's not even related to abortion. So Nebraska also, Lieutenant Governor Mike Foley, when he was a state senator, was instrumental in passing legislations related to assault on fetal persons and homicide a fetal person's, that causing the death of an unborn child through an assault on the woman. So that's some of the work that we've done. Some of it is cultural and related to public witness, and some of it is legal. And those things help to, again, undermine the lies of the foundation of Roe v. Wade, educate the public about what's actually going on here, and remind people about the dignity of unborn life and of all life. So that leads us then to, and I should say here too, part of what we're talking about here is how these things happen and the difficulties that we encounter, because you'd love to be able to simply pass laws that regulate or eliminate abortion, and just take a stand simply on the truth, the whole truth, and nothing but the truth, and just make it happen. But the reality is that we're living in a culture, right, where it's an illegal culture where if we want to advance the ball in a meaningful and permanent way, right, we have to understand sort of the terrain on which we stand. And it's not possible to pass legislation and hope that it will stand up when we're living in the midst of a legal regime around Roe v. Wade and operating within a structure that's built on a foundation of lies. So what we have to do is to work on reform, to toppling this entire structure, which has to be built again on public consensus and an understanding of what true law is. And if there's anything that we know about the Supreme Court, it's that regardless of the legal merits around laws, around challenges to laws regarding abortion, regardless of the merits of these pro-life laws and of the truths that they represent, they will not do anything to upset the status quo unless they believe that the culture at large is ready for it. And that has been one of the big frustrations of all of us working in the pro-life movement. But it's the reality that we have to understand, that we have to witness to the culture and reform the culture. And some of that is done through the passage of laws that really teach. And some of that is done through non-legal means. But if we want the Supreme Court to overturn Roe v. Wade, if we want then to be able to outlaw abortion in our states, and we want to actually decrease the demand for abortion and decrease the supply to disincentivize people from going into this field, this distortion of medicine, what we really need is to build a national consensus around the dignity and worth of all individual human lives. And so that's the situation in which we find ourselves. And if you ever find yourself a little bit frustrated that we're not able to move the legal ball into the end zone, understand that's kind of what we're working with, is the unwillingness of courts to do more than they think the nation is ready for. So what we're trying to do is protect as many human lives as we possibly can, to save as many lives as we can, and also to teach the culture at the same time about the value of human life. And we have to get more and more creative to do that as the court comes up with more and more rules about what is acceptable and what is not. But now we find ourselves possibly, in sort of a new, a time of hope, right? Where we have, with the hopeful confirmation of Amy Coney Barrett onto the U.S. Supreme Court, perhaps the Supreme Court will be changed in such a way that they may be willing, they may have the sort of courage to stand up for the truth and to stand up for our own legal, cultural, historical tradition and true understanding of the law, and to repeal Roe v. Wade, to overturn Roe v. Wade. And that may be true, but I do want to, again, to emphasize that it takes a lot of courage for people in high places, for lawmakers and for judges and others, to stand up when the cultural winds are blowing. And so they need our prayers and our support and our work, our constant work. And I also want to emphasize that it's very important that we don't place our hope in princes, whether they are in the presidency or in Congress or in the U.S. Supreme Court. There is the Lord is our sure hope and foundation, and human beings are not the people in whom we place our faith, and we do so at our peril. We do so at our peril. So, winning public sentiment, building a culture of consensus around the dignity and worth of human life, that recalls to mind our true identity and therefore the special dignity of the human person. Yes, we are in the right, those of us who are fighting for life. Yes, we must continue to fight and have courage. That is clear and that is indispensable. But our political and legal system is built on popular consent. And so we must do all we can with God's help to win popular consent for the proposition that every human person is of infinite value and must be protected by the law. And where will the lawyers and the judges and the statesmen and women who will redeem the law and restore this beautiful, wonderful Christian, classical and Christian tradition about the common good and the dignity of the human person, where will these people come from if not from our own families and parishes? Those men and women will come from our state. They will come not just from Lincoln and Omaha, but from little towns. And they'll come not just from affluent school districts, but from poor school districts. Remember Clarence Thomas for a lesson there. And we have to pay attention then to the formation and education of children and to foster in them the virtue of magnanimity, this sort of forgotten virtue, which is greatness of soul, the crown of the virtues, this desire to do great things for God. And we must teach them to speak the truth, not only with courage, but also with charity. Because again, what we have to build here is cultural common consensus. And so the law is a teacher, and as we pass good laws, it will help to reform the culture. But if we want the protection of life to stand on a firmer legal foundation than Roe, or a firmer legal foundation than slavery, things which have caused so much tumult and so many wounds, we must transform the culture itself with patience. That cannot be repeated enough, with patience, but with diligence and trusting only in the Lord. And so trusting in him then and abandoning ourselves entirely to his will and to be willing instruments of his providence. Thus we work to redeem our time and hopefully work to redeem the law.
Thanks, Marion. A lot to unpack there, and I know that we have some questions already coming in, but just a reminder to those wanting to ask questions, you can type them into the Q&A box or to the chat box. Before I get into those, Marion, I want you to talk a little bit about, I think you spoke a lot about our elected officials and how it takes a lot of courage and willingness to step out on a limb to support good policy or for our judges to make certain decisions. And so I just want to say that's a really good reminder of how we need to pray for them. Here in our office, we pray by name for our elected officials every day. I know that we can do it even more. And so I just want to remind all of you, that's a huge thing that we can do as Catholics, is to lift up those elected officials, those judges, in prayer, so that they will work to uphold and pass laws that respect human life. I also just want to remind, I know you went quickly through some of the laws that we've passed here in Nebraska recently. I want you to talk a little bit about the one we recently passed, LB 814, to ban dismemberment abortion in Nebraska. A huge pro-life victory. We kind of scraped by. This is why local elections are so important. Things that happen in our state legislature, the people that we elect to those positions. it's so important that we elect good people. But Marion, during the course of debate for LB 814 to ban dismemberment abortion, our opponents would say that this was unconstitutional, that there were a lot of issues as it pertained to some Supreme Court decisions. Can you just talk briefly about why we felt that this was on, sound constitutional ground, and why we felt like this was a good law to pass here in Nebraska?
Yeah, sure. So so after Roe v. Wade in 1973, the next sort of really foundational structure in the legal foundation for abortion law is Casey versus Planned Parenthood, or Planned Parenthood versus Casey, which is in 1992. And that laid out sort of a new framework for determining whether a law that regulates abortion is quote constitutional. So that's the framework that we're operating in. And this new framework said that in order for a law restricting abortion after the point of viability, so after the point at which the child might actually survive outside the womb of the mother, if you're going to pass a law that restricts abortion after viability, you may do so long as this restriction does not erect a substantial obstacle in the path of a woman seeking an abortion. So that makes things kind of tricky sometimes, because what you really want to do is limit abortion to the extent that you possibly can to save lives and to save women from the trauma of abortion. But what we found with dismemberment abortion in the state of Nebraska is that while it is the most common second trimester abortion method nationwide, it's actually not very common in Nebraska at all. There are other methods that are used that are of course, in some ways just as barbaric and awful as dismemberment abortion, but which are not quite so brutal and so painful, especially for the unborn child. And so, the argument that we were able to make is that, listen, dismemberment abortion happens in Nebraska, but it's not all that common. And we can ban this particularly barbaric and disgusting method of killing unborn children without actually substantially burdening access to abortion overall in the second trimester. And so that was the legal argument that ultimately won the day. And we had friends in the state legislature, particularly Mike Hilgers and Andrew Legrone, who are attorneys, and both Catholics in the state legislature, who helped make this argument that ultimately won the day. So the legal argument there is that while this does restrict abortion and it bans a particularly brutal and inhumane method of abortion, it does not, on the whole, erect this undue burden on abortion access in the second trimester in Nebraska. But, and part of the reason we were so excited about that here is that as a sort of legal strategy, it was really significant, because dismemberment bans had not been upheld anywhere in the country, in other states, because they were substantial obstacles. They were, quote, undue burdens on abortion access, because they were like 100% of the second trimester abortions in those states. So here, what you can do sometimes is force what's called a circuit split. So kind of what part of what we would love to see happen is for Planned Parenthood or somebody to challenge our dismemberment ban, and then it goes up to a court, and the court looks at the facts and says there's no undue burden on abortion access created by this law in the state of Nebraska. And then it becomes the first court to uphold a dismemberment ban, right? So this forces what's called the split between legal jurisdictions and how they've ruled on the issue. And sometimes that can force an issue up to the U.S. Supreme Court, who then takes the issue to resolve the difference, to resolve the legal incongruity that's been created. And that is ultimately one of the things that one of the goals of this legislation is, if they don't challenge it, then great. We've outlawed dismemberment abortions forever in our state. If they do challenge it, we have a really good opportunity to win, and that may force another domino to fall on the way to overturning Roe v. Wade.
Awesome. Yeah, thank you for that. We have a couple of practical or short questions from the audience. There's two about abortion clinics, so two-part question here. Are abortion clinics required to meet medical standards the same as those required of hospital delivery rooms? And then another abortion clinic question is, could we require, and I'm assuming that means could we make a law that every abortion clinic have a pro-life counsel for each woman who comes in for an abortion?
Yeah, good. Those are both good questions. The first one is the answer to the first question in a word is no. And that's part of what Justice Scalia, the late Justice Scalia, used to talk about, what he called the abortion distortion. And it's this distortion of the law that was created by Roe v. Wade and the legal progeny of Roe v. Wade, which is that it tends to distort everything that it touches. And that this made up, this judicially created right to abortion tends to, in the words of Justice Alito, bulldoze everything in its path, including all of our legal traditions and rules. And so because the standard right now is, will this unduly burden abortion access? And that is the controlling standard. And then any law that's passed that actually tends to sort of shut down abortion access automatically becomes very vulnerable in courts. So you saw in Louisiana, for example, Louisiana has this awful history of unsanitary, awful abortion clinics, and at the same time, they have a history of passing these really wonderful pro-life laws. And if you remember the Kermit Gosnell scandal, in which they found this filthy clinic in Philadelphia, and he was murdering children who had already been born in the clinic, and injuring and even fatally injuring, in some cases, the women that were coming in for his late-term abortion services. Louisiana passed laws in the wake of that, while that was all in the news, to really regulate these abortion clinics, these facilities, and bring them in line with standards that were applicable to the whole medical field, including delivery rooms, for example, as you mentioned. And the court ended up striking that down. And the reason is that these regulations often are such that the abortion industry says, if we have to abide by these regulations, it will put us out of business. That is how bad the abortion industry is in many places at just upholding standards, regular baseline standards of healthcare in their clinics, such that to reform their practices to bring them into just sort of modern baseline standards of sanitation and cleanliness and order, they say would actually put them out of business. And they've won cases making those arguments. They've shown how financially that would make things too difficult for them. And so the short answer is, this is one of those areas where it's good to pass laws to push those boundaries, because first of all, they protect the health of these poor women who come into these clinics if the clinic is actually expected to uphold some standards of sanitation. But they also, when we pass these laws, they also educate people about how awful these places are, not only because they're injuring women and killing children, but because of just how dangerous they are in many ways, and to the poor health effects that can have on the people who come into contact with them. So those are good reasons. They're really good reasons to push the boundaries, to push the envelope without introducing and trying to pass those types of legislation. But the tricky thing is trying to stay in bounds with this sort of distorted legal structure that we have to operate in. But we're always pushing on it, and we're always pushing on it. And hopefully the court is in a position now that we can push a little harder, and reform the law in the ways that we've been talking about in a lasting way.
And the other part of that question, I don't think you answered about could we make a law that would require a pro-life counsel in every abortion clinic?
Yeah,
I guess
I'm sorry. Yeah, that's a good question. That is, again, I think that's going to be a really tricky thing. So we have these informed consent laws, right? That say that the abortionist or somebody on the staff has to tell women about like complications that may arise, or the fact that hey, if you're being coerced into abortion, that's against the law, and there are legal resources available to help you defend yourself against coercion, things like so we can do that. I think though, it's an interesting question, and of course, just at the purely conceptual level, it's a wonderful idea. But I think you may run into some questions about the First Amendment rights of these abortion practitioners, and not wanting someone who would speak a message that's contrary to their message in the place that they're doing their business, right? So even informed consent laws, you have to be pretty careful about not infringing on First Amendment freedom of speech. And I think if you put a person in that same room that's required to be there, I think it gets pretty difficult to sustain that. I think when you're talking about First Amendment freedoms of the persons who are there delivering their own message. So while you can require them to talk about legitimate, non-misleading, truthful information, facts relating to the risks of abortion, I think it gets really tricky when you're talking about putting another messenger in there to contradict their own message. But what we can do, right, is so much of the great work being done in the pro-life movement is done by sidewalk counselors. And that's part of that's what they're trying to do. So be a sidewalk counselor, support sidewalk counselors. They're doing awesome work.
Yeah. And, for instance, with the story that George told, a woman walked into the crisis pregnancy center thinking that it was an abortion clinic. So, those pregnancy centers that we have across from abortion clinics, any opportunity that a woman has to feel supported and loved are going to be really important in those cases. So,
yeah.
And then just one last question about something you mentioned, the exception for the health of the mother. How is that necessary in law? As we write laws and pass laws, is that exemption necessary?
Yeah, well, that's another. that's also tricky territory in this distorted legal edifice that all this abortion law is built upon. Is that people don't realize that Roe v. Wade and its companion case, Doe v. Bolton, which are to be read together, the Supreme Court said those cases are to be read together, not only struck down the abortion laws that were existing all over the country, but they also built in these requirements that if you do restrict abortion, whether pre-viability or post-viability, all the way up to the point of birth, you must not infringe on a woman's right to abortion if it's necessary to save her life, or if it's necessary to protect her health. And the way that the Supreme Court defined health in the Doe v. Bolton case was everything. It's it's not only related to whether giving birth or just continuing to the full term of pregnancy would endanger her health permanently in some way, but also these sort of familial and psychological factors were to be taken into account too, including size of the woman's family, the woman's age, all these things that are in some cases related, at least sort of tangentially, to the woman's physical health, but all these factors that only have a bearing on what you might consider a woman's psychological health or mental health. And so what that broad definition of health did was effectively mandate abortion on demand through all 9 months of pregnancy on the entire country. And one of the things that we've been trying to do ever since then, again, is to push the court on that health issue and get them to restrict that definition of health to something that's more meaningful. And ultimately, of course, the goal is to completely eradicate abortion, period, and to protect life in the law. But again, that is done through knocking out these nonsensical foundations that underlie that hold up this entire edifice. So I got a little bit ahead of myself. So the question specifically had to do with, whether those exceptions are necessary, right, in the law. So the approach that national pro-life groups and groups like ours, kind of following their lead, have taken over the past 40 plus years has been to have those exceptions built in, but in a way that again really constricts and pushes back against the expansive meaning of those exceptions. Because what we want to do is, in order to save lives, we have to have the law upheld in the courts when it's challenged. So we want to give the law a fighting chance in court, and so we have to build some kind of exceptions in. But what we're trying to do is really push back against this really super expansive definition of life and health that really undercuts the whole notion, the whole purpose of the law in the first place. So ultimately, that will be overcome, I think. But that's another difficult area in the law that we have to push back against, and we're working on that all the time. I hope that's a helpful answer.
In short, there's a lot of these things that are really tricky and a big mess. So we are working to try to work with the laws that we have to, like Marion said, to push courts on these definitions and to try to protect the child and mother in every way. So thank you, Marion, for that talk, for taking us through the history of law, no, at least the history of abortion law, and what we can do here in Nebraska. We could talk about this all day, I think, and many of you would stick around for the conversation, but we want to honor your time. Again, these talks have been recorded. We'll send them out early next week. If you can't wait that long to share or to rewatch, this was streamed live on Facebook, so you can go to our Facebook page, Nebraska Catholic Conference, and find the video there. You can share it with your friends there as well. I just want to thank, although some of them have left us already, thank Archbishop Lucas from the Archdiocese of Omaha, Bishop Hannafelt from Grand Island, Kevin Grillo and Christina Whalen for their contributions this morning. A big thank you, obviously, to George Weigel for being our keynote. We were really excited to welcome him to Nebraska in person, but COVID happened. So we're hoping that we can bring him in person for another talk, and we hope you all can come to that when we can all meet together and party again. Again, be sure to vote in whatever way you feel comfortable. It's really important for Catholics to have their voice in the public square, not just in voting, but also in making our voice heard to public officials, to maybe praying about being a public official ourselves, writing letters to the editor, being a voice for the voiceless. These are all really important things that we as Catholics need to do. And the Nebraska Catholic Conference is here to help you to bear the light in the public square in any way that you need. So We are here at your service, remember, so you can always contact us at our office. You can go to our website or our Facebook page. We are here to help you and to help advance the mission of the church in Nebraska and the country and the world. So thank you so much for tuning in today, for being active participants, and for sticking around. And we look forward to seeing you all in person very soon. Thank you, God bless, and go Big Red. Bye, everybody. Oh, bye, Archbishop. Thank you.